Happy Monday, and welcome to another episode of Cases That Should Have Gone to the Supreme Court of Canada, but didn't. Today, we're talking about searches and exclusion of evidence. Cases that should have gone to the Supreme Court of Canada, but didn't. Mr. St. Clair was arrested for a drug offense. He produced at the time a card showing that he was entitled to be carrying the drugs that he had. The police didn't feel that it was genuine, so they continued with the arrest. They searched his vehicle incident to arrest, found a loaded handgun. He was arrested for that offense, taken back to the police station, subjected to a strip search, which revealed the presence of cocaine. At trial, the judge ruled that the searches were unlawful, but allowed the evidence to be admitted anyway. Mr. St. Clair appealed, and at the Court of Appeal found that the trial judge's rulings were valid, but that they would have admitted the evidence under something known as the doctrine of discoverability, the sense that the evidence would have been discovered anyway, even without the unlawful activity of the police. This was a new consideration that was not argued before the court below, nor was it argued before the Court of Appeal, but something that they added in of their own accord. Mr. St. Clair sought leave to appeal to the Supreme Court of Canada on the issue of adding in this extra consideration that had not been argued and for which the court did not have the benefit of submissions. And this case does raise a very important issue, particularly where the decision that the Court of Appeal is making on whether or not the analysis of excluding the evidence was correct needed to be something that was fully fleshed out. We know in appellate cases that there needs to be a proper record from which to appeal, because issues that weren't argued at the lower court can't be decided anew on appeal. But when the Court of Appeal of their own motion introduces a new consideration not arising from the evidence or submissions, shouldn't the parties have the right to be heard on that? Isn't that an element of a procedurally fair appellate hearing? And this was an opportunity for the Supreme Court of Canada to really chime in on these issues, particularly where discoverability is something that's part of the factual matrix that's analyzed in a 2042 decision, even if it may not be explicitly argued by the parties. And how do we draw that line between what the Court of Appeal is allowed to consider and what the Court of Appeal is not allowed to consider based on what was argued below, even though these things may be relevant considerations in determining whether evidence is ultimately admissible? This is an important case because it allows people to understand better the risks and potential rewards when bringing an appeal, particularly on a case that hinges upon one single ruling that a judge has made. Ultimately, the Supreme Court of Canada has kind of left the door open for appellate courts to intervene by providing their own information about what may have been a consideration on a 2042 that didn't get the benefit of submissions, the positions of the parties, and any case law relevant to the issue being brought to their attention that the judges may not have been aware of. Hopefully, the Supreme Court of Canada does intervene in the future to try and provide more direction on these types of issues before people are convicted without having the opportunity to fully argue their cases. Cases that should have gone to the Supreme Court of Canada, but didn't. Thank you for tuning in to another episode of Cases That Should Have Gone to the Supreme Court of Canada, but didn't. I'm Kyla Lee at Acumen Law Corporation. Thank you to Brazen Bull Creative for putting together these videos. Please like, subscribe, and share with your friends.